Welcome back to Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. We're pleased to welcome Ted Frank, Director of the Center for Class Action Fairness at CEI, who the New York Times has called the leading critic of abusive class action settlements. Ted, welcome back to the show.
Happy to be here. You're my favorite interviewer.
Ted, as an attorney who's focused on class action abuse for years, I asked you on to analyze the pending cases that could spell doom, not only for ride-sharing services like Uber and Lyft, but for many companies in the new sharing economy. A Boston-based former labor union lawyer named Shannon Riordan is on a crusade to persuade government regulators to force Uber to stop using independent contractors and hire all the Uber drivers as employees. What are the legal differences between employees and independent contractors?
Well, employees are subject to a variety of government mandates. If you have an employee, you have to pay certain taxes for them. You have to comply with certain wage and hour regulations. You have to provide health insurance if they're working for more than 29 hours a week, or pay certain penalties for that under the Obamacare laws. So there are a variety of restrictions or requirements if you have employees. But not every labor relationship is an employee relationship. If you hire a plumber to work on your sink, they're acting as an independent contractor, and then you as the homeowner who's hired the plumber don't have to comply with the various government mandates. You have an independent contract with them. They're working for themselves, or they're working for a plumbing company that you've hired. So an Uber that tells its drivers, hey, just sign on to the system, work as much, work as little as you want, and we'll be happy to send you rides. They want to have independent contractors, because if they have employees, they don't have the same sort of flexibility.
Well, why else would it be so problematic for Uber and Lyft if they were forced to take on all their drivers as employees?
Their business model simply doesn't work like that. Take, for example, wage and hour regulations that require a certain minimum wage. Right now, Uber doesn't police productivity. A driver drives as much as they want, and they pick up as many rides as they want. It's up to the driver to be in the most productive area possible, because they get paid by the ride. If they're getting paid by the hour, suddenly Uber now has to measure making sure that the drivers are in the right places. They have to assign certain hours. They can't have employees that only work 3 hours in 6 months.
And they're not hanging out in the donut shop.
They're not hanging out in the donut shop. And then what counts as part of the hour? Does time waiting to pick up riders count? Right now, Uber drivers have an incentive to go find the riders as quickly as possible, because they get paid, and therefore they have an incentive to be where the riders are. If the drivers are getting paid by the hour, no matter how many people they're picking up, they have an incentive to just sort of drive around in the suburbs somewhere and not have to deal with customers. And then Uber has to police their productivity in a way that they don't have to police the independent contractors. But then there are other regulations that just sort of make it impossible. If you're in California, for example, employees have break time, and it's mandated break time. And if you don't give them that 15-minute break, you're liable for just gigantic penalties. And how do you enforce that when your driver is out there as an employee miles and miles away? What happens if they're in the middle of a long drive at the time? Does the driver have to be pulled over and told to stop? It just doesn't work as an employee-employer relationship.
Most UberX drivers use their own personal cars. Would Uber be forced to buy a fleet of cars like the taxi cartels, or could Uber be sued for discrimination if they refused to hire drivers who didn't provide their own cars?
There are all sorts of problems like that also. If the requirement is that the driver have their own car and the car be kept in a certain fashion, there would be real consequences. And you have this rating system. And if customers are rating drivers poorly, Uber just doesn't let them sign on to the system anymore. And if they're employees, they have a potential discrimination case. So you accepted that customer's criticism of me, and you shouldn't have. It opens them up to all sorts of liability that they wouldn't have otherwise.
I've been using Uber for about a year now, and I ask every driver I ride with whether they like it. I've never met an unhappy one, and not a single driver said they would prefer being an employee rather than an independent contractor. They love the flexibility. To what extent, then, is Shannon Lyst Riordan representing the interests of most drivers in her class action suits?
Well, she's really not, because the world that she would get is not the world where Uber drivers get all the flexibility that they currently have, and then they get all the benefits of being employees also. The world she's asking for is the world where Uber goes out of business, and this isn't just hypothetical. HomeJoy, which provided me maid service for months and months, decided to shut down because they couldn't find financing willing to deal with the litigation risk of what Lyst Riordan was going to put them through, and so they just shut down.
If Shannon Lyst Riordan is not really representing the Uber drivers, whose interest is she representing?
Well, she's representing her own interests. She's looking for the millions of dollars of fees she can get if she can extort the company into settling with her to drop the litigation. But with wage and hour litigation, there's a certain disconnect. If you're a former Uber driver and you don't plan to go back to Uber, and you've already collected all the benefits of the flexibility, and you can go back to them and use the law to say, oh, you should have paid me more. I know we had this contract where I got all this flexibility and you only paid me by the ride, but now I'm going to tell you that you should have paid me for my break time, and you should have paid me by the hour, and you should have reimbursed me for this, that, and the other, and I want to retroactively modify my contract. I, as that former independent driver, don't care that this is going to ruin the lives of all the current drivers.
It's a free lottery ticket.
It's a free lottery ticket. So you have that sort of conflict of interest between the former drivers and the current drivers. And unfortunately, courts haven't recognized that, and they've permitted, in the Uber case, to have a single class certified rather than a class of people who are current drivers versus a class of people who have quit driving and just want a free ride off of retroactively modifying their contracts. But the people who will have their contracts prospectively modified so that the company goes out of business or that they can no longer drive for the company because, presumably Uber will cap their drivers at 29 hours a week rather than risk Obamacare liability. No company can run itself by saying, oh, just show up for work whenever you want and we'll pay you by the hour. And if you work more than 40 hours a week, we'll pay you overtime. Uber won't let that happen. It's very hard to see how they can continue under all the restrictions that employers have for employees. Just to take a really basic one, the Department of Labor requires that the employer post in a conspicuous place certain notices. And, if you have a workplace and you go into the lunchroom, you probably see a large bulletin board filled with compliance notices letting you know all of your rights as an employee. Well, how do you do that for a driver? Do you how do you require them to drive to a central office and look at the bulletin board? There are all sorts of laws and regulations for employees and employers that just do not coincide with the business model of an Uber.
So, Ted, under class action law, how can the voices be heard of people supposedly being represented in the case who disagree with it?
It's unfortunate that there are very few opportunities to do that as the case is pending. Courts simply do not recognize that a class action attorney pursuing a cause of action might not be operating in the interest of the class, and they just assume that they are. And Uber, in this case, tried to convey otherwise, and they had affidavits from hundreds of drivers saying, Miss Lyst Riordan doesn't represent me. What she's doing will make my life worse. And the judge just ignored those on the theory that, well, they can opt out, except with the sort of lawsuit that she's doing that seeks injunctive relief that will affect all the drivers. The drivers can't really opt out. You have, again, this conflict of interest, and nobody thinks to say, well, if the drivers don't like it, they can get another job. There are taxi companies hiring with employer-employee relationships if that's the business model you want. And why not give everybody a choice? You have this sort of regulation through litigation that's very unfortunate and can make the putative beneficiaries much worse off.
Ted, if I can share a brief story, I took an Uber ride earlier today and chatted up the driver like I always do. It turns out he's a former car salesman who switched to Uber because it gave him both shorter hours and more flexibility. He says he now works about 44 hours a week, makes about $1,000 a week, and anytime he wants to take a week's vacation, he just works time and a half a week before and a week after. I asked him if he'd like to give up his independent contractor status and become a full-time Uber employee, and he said no way. If that happened, he'd go back to selling cars, and he thought Uber would probably go out of business. Is that the goal here? Do labor unions want to drive Uber and other sharing economy companies out of business?
Well, certainly the competitors of Uber that are affected by Uber, the labor unions, the taxi companies, the owners of taxi medallions, the people who've been protected by the crony capitalism and regulations, don't like to see this new competition, and they don't like drivers being better off without unions. They don't like this flexibility. It's good for consumers, and it's good for the drivers, and it's not good for the vested interests. So they certainly have an interest in lobbying for regulations or trying to get the government to act against Uber.
I understand Lyft reached a settlement in one of the class action suits filed by Shannon, Lyst, Riordan. What were the terms of that settlement?
They're remarkably puny, but they will likely be very profitable for Ms. Lyst Riordan. Lyft gets to keep calling its drivers independent contractors, which I think they pretty clearly are under the law. They had some minor modifications to the contracts with the drivers that Lyst Riordan's taking credit for. And they're going to put $12 million in a fund as sort of the extortionate payment to get out of the litigation, and that's probably less than that they would have spent on lawyers trying the case. And Ms. Lyst Riordan is going to claim $3 or $4 million of that for herself, which she has a pretty good chance of the judge giving her.
Sounds like a pretty profitable business.
That's why she brings these lawsuits. She knows this area of the law very well and looks for opportunities where companies have independent contractors to try to assert that they're not really independent contractors, that they're employees. And unfortunately, it would have been really easy for the IRS or state labor regulators to just say, you're an employee if the business says you're an employee, and you're an independent contractor, the business says you're an independent contractor. And instead, a lot of jurisdictions have 19-part tests. And that's very good for lawyers when it's a 19-part balancing test, and it's very bad for business that you don't have the certainty you need. And that lack of certainty means that an Uber or a Lyft can't make the litigation go away quickly. And even if they think they have a very good chance of prevailing, the tiny percentage chance that they'll be driven out of business, or it's a slightly larger than tiny percentage of a chance when you have an unfriendly judge, as Uber unfortunately does, means that it's cheaper to pay extortion to get out from under the litigation and get the certainty that you wouldn't have been able to have otherwise.
So what's the current status of the Uber class action lawsuit?
Well, the judge certified a class on, as we mentioned, questionable terms. Uber had arbitration agreements with many of its drivers and sought to enforce those agreements, which would have precluded the class action for many of the drivers. And the judge said, I don't want to enforce these contracts. I don't like arbitration, and I'm going to consider them unconscionable and refuse to enforce them. And that lets the drivers in. So Uber put in new contracts that are pretty clearly enforceable under the law. And they give the contract to the driver, and they have a certain amount of time to say, I want to opt out of mandatory arbitration. And that's enough to do it. And most drivers are perfectly okay with mandatory arbitration. The only people who don't like mandatory arbitration are lawyers. There, it's sort of the same thing. Lawyers are the taxi cartel, and mandatory arbitration is the Uber that provides a cheaper, better alternative.
As the Uber lawsuit proceeds, why is Shannon Lyst Riordan trying so hard to avoid a jury trial?
Because settlement is guaranteed payment, and if she gets a jury trial, first she has to win, and then even if she wins, there are going to be years of appeals. But she's afraid of actually having to put this in front of a jury. Uber drivers like the flexibility. They like the current status quo. And if the jury hears from dozens of these drivers, and Uber does a good job of picking the drivers to come before the jury to say, I like what we're doing, and I don't like what this lawyer is going to do to my life. If she wins this case, the jury might very well be sympathetic to the drivers. But I think there's a danger to Uber as well if it goes to a jury trial, because juries don't always get it right. There's some small percent chance that no matter how good the law and the facts are for Uber, that the jury will come to the wrong conclusion and put them out of business. That's a very dangerous thing for both sides, and both sides don't like the uncertainty. But I think Uber has a better chance of winning this than Ms. Lyst Riordan if it actually goes to a finder of fact.
If Uber decisively wins this suit, what prevents Shannon Lyst Riordan from filing another one somewhere else?
Well, she has a certified class, and any decision she gets will affect the people that are in that certified class. But down the road, there'll be other drivers that join Uber that aren't in this class because they'll have joined Uber after the litigation's over, and she could presumably start all over again. It would be tricky because you need a class large enough to sort of justify the attorney's fees that she would be seeking. But there are other jurisdictions out there. There are other people who aren't affected by this, and she's going to keep coming at it over and over. And it's possible taxi companies will successfully lobby government to come at this over and over.
Ultimately, will legislation be required to protect the right of independent contractors to work in the sharing economy?
Legislation would help prevent the uncertainty. And it's unfortunate to see one political party's presidential candidates be sort of proponents of the opposite tack, adding uncertainty, creating problems for the sharing economy, and criticizing the sharing economy that makes things better for both workers and for customers and consumers.
Ted, at the Center for Class Action Fairness, you spent a lot of time exposing problematic cases, including those that use class action as a means for creating what you call extortion leverage. Exactly what do you mean by that?
A litigation's very expensive for a defendant, and the lawyer can always go to the defendant and say, look, you're going to spend millions of dollars defending this. If you win, you're out millions of dollars. You might not win, and I can resolve the uncertainty. Just pay me the millions of dollars you would have paid your lawyer instead. And they can use a settlement process that, as long as you don't pay money to the actual putative victims that the lawyer is defending, to sort of extract a lot of money from the defendants. And that's very profitable, even if the underlying litigation is completely meritless, just because of the expense of litigation and the fact that the lawyers have the power to impose that upon defendants, regardless of the defendant's actual culpability.
From an economic growth perspective, what happens if we freeze our labor laws designed for 1950s-style workplaces as we try to innovate a 21st century economy?
Well, Uber has done marvelous work, right? They've made taxis available to neighborhoods that normally wouldn't have that sort of ride availability. They've probably saved dozens, maybe even hundreds of lives by providing people with flexible ride service when otherwise they might end up being drunk driving. It's a really remarkable service that's created so much consumer surplus, created so many opportunities for workers. And these sorts of gigantic regulations on the employee-employer relationship, if imposed upon Uber and its drivers, can drive them out of business. And we lose all of that benefit. We've already lost it with HomeJoy, which has been driven out of business by the threat of Ms. Lyst Riordan. And that's what she's trying to do to Uber. Though I presume she doesn't want to kill the golden goose and just wants to extract millions of dollars of legal fees from them. But these are very dangerous laws, and they create a real problem for the growth in the economy. The class action system and its abuses transfer millions of dollars of wealth from consumers and shareholders to wealthy lawyers who are simply rent-seeking. And that's one of the things that the Center for Class Action Fairness does, is to sort of try to limit the abuse of the class action system through abusive class action settlements and hopefully in the future abusive class action certifications, and protect consumers and shareholders from these sorts of predations.
Ted, thanks for filling us in, and thanks for coming on the show.
Thanks for having me.
That was Ted Frank from the Center for Class Action Fairness here on Real Clear Radio Hour, brought to you by the Competitive Enterprise Institute. I'm your host, Bill Frezza. Real Clear Radio Hour is a partnership with Real Clear Politics, which the New York Times has called an invaluable tool for anyone interested in politics or public affairs. You can check out Real Clear Radio on Facebook or follow us on Twitter at Real Clear Frezza. Every once in a while, a broader political issue touches your personal life, and this is one of those for me. After 2 decades in the suburbs, I'm a city dweller now, and not a single urban transportation advance has improved my life more than Uber. Thanks to the sharing economy, I don't even own a car anymore, and I'm happier for it. As both the grandchild and the husband of an immigrant, I also appreciate the tremendous opportunity Uber offers newcomers to both make a contribution to our economy and get themselves started in life as independent entrepreneurs. Riding with Uber here in Boston is like a visit to the UN. I've met so many interesting people who work part-time, full-time, they're going to school, they're hustling, they're raising families, they're paying taxes, and they're getting things done. To think that they might be thrown out of work to protect a regulatory scheme designed to address the shortcomings of a century-old factory economy is preposterous. The last thing our stalled economy needs is a straitjacket. If you want to live a better life than your parents, which used to be virtually guaranteed in America but no more, you'd better not let the lawyers and regulators kill off the innovators and entrepreneurs. That wraps up our show for this week. Please join us next week, same time, same station. See you then.